Yo, there we are. We're live. Welcome, America. Glad to see you. Hope everybody's doing all right. You're listening to Restore the Republic, the voice of the people who's had enough. Enough of corrupt judges, enough of the rogue cops, enough of the lawyers who twist the law and the politicians who trample it. This is a show that dares to ask what happened to you, the de jure American government, and how can we get it back? I'm your host, Sheriff Andrew Ike on the unincorporated Richland County, Ohio, and every week we expose the lies and decode the legal traps that empower you to reclaim what's rightfully yours. No fluff, no compromise, just facts. With me as always, Sheriff Adam Bonner on the unincorporated Summit County, Ohio. How's it going, Adam?
Excellent. How are you tonight?
Doing good, doing good. And with us again, the one and only Chad Morgan, the unincorporated Idaho Assembly Chairman. How's it going, Chad?
Listen, man, thanks for having me on again.
No problem. I think the people like you.
I don't care if they do or not.
That's good. That's good. Hey, that's freedom. You know, you don't have to like us. Just subscribe, damn it. Now, anyways, tonight we're going to take a little deep dive into oaths and bonds. You know, we try to keep everybody out of the court system that's going on now, the C jurisdiction courts. You know, we talk about that all the time. We're not looking for individual remedy. We're not looking for UCC and learning all that crap and everybody getting confused, because you got to know what you're talking about. You got to be studying if you're going to go that way. You know, and here in the unincorporated United States, the assemblies in the states, we are pushing, you know, towards restoring our lawful courts. That's the whole deal that we got going on. You know, that's what we're doing. So we're trying to get our courts up and running. But in the meantime, like some of these other YouTubers want to do, you know, they want to give you a little bit of remedy. I think we're going to get into a little of that tonight, you know, about these oaths and bonds, you know. So in the meantime, before your court's up, you can look into some of this stuff. So we're going to start off tonight with going through, I think it's about 22 maxims, you know, maxims of law. And yeah, just listen to them and listen carefully, because they could pertain to you. Go ahead, Adam.
Well, I mean, there's a ton, but, you know, these specific ones will pertain to what we're talking about. So all men and women know the foundation of law and commerce exists in the telling of the truth and nothing but the truth. So truth is a valid statement of reality, is sovereign in commerce. An unrebutted affidavit stands as truth in commerce. An unrebutted affidavit is acted upon as the judgment in commerce. Guaranteed all men shall have a remedy by the due course of law. If a remedy does not exist, or if the remedy has been subverted, then one may create a remedy for themselves and endow it with credibility by expressing it in their affidavits. So that's where you can kind of do conditional acceptance. That's kind of what that's referring to.
Yeah, as a matter of fact, I'll touch on the conditional acceptance. One thing that did happen to me was I had a couple liens placed on my business when I unincorporated, right? And they sent that to me, and they filed liens on my business. And so I sent them a conditional acceptance. And I gave them 10 days. I would conditionally accept their offer to contract via the liens if they could prove that the Idle Falls Plumbing Company was functioning as an incorporated entity. The state of Idaho had physical borders. And I lined it all out. Man, within 10 days, I got apology letters and lien release notices.
Awesome.
Yeah.
I like it.
Yeah. So ignorance of the law might be an excuse, but it is not a valid reason for the commission of a crime when the law is easily and readily available to anyone making a reasonable effort to study the law. All corporate government is based upon commercial affidavits, commercial contracts, commercial liens, and commercial distress. Hence, governments cannot exercise the power to expunge commercial process. The legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard. No bond means no responsibility, means no power of official signature, means no real corporate political power, and means no privilege to operate statutes as a corporate vehicle. The corporate legal power is secondary to commercial guarantors. Case law is not a reasonable substitute for a bond.
Interesting.
There it
Yeah,
is.
yeah, that's powerful stuff. So if you get into municipal corporations, which is a lot of what we're dealing with today, which includes cities, counties, states, and national governments, they have no commercial reality without bonding of the entity. So its vehicle, statutes, and its effects, the execution of its rulings, in commerce, it is a felony for the office, public office, to receive and report a claim to its bonding company, and it's a felony for the agent of a bonding company to not pay the claim. So if the bonding company does not get the malfeasant public official prosecuted for criminal malpractice within 60 days, then it must pay the full face value of a defaulted lien process in 90 days. Except for a jury, it's also a fatal offense for any person, even a judge, to impair or expunge without a counter affidavit any affidavit or any commercial process based upon an affidavit. Judicial non-jury commercial judgments or orders originate from a limited liability entity called a municipal corporation, hence must be reinforced by a commercial affidavit and a commercial liability bond, which they never have. So
Yeah.
Yep. A foreclosure by a summary judgment, non-jury, without a commercial bond is a violation of commercial law. Governments cannot make unbound rulings or statutes which control commerce, free enterprise, citizens, or sole proprietorships without suspending commerce by a general declaration of martial law. It is tax fraud to use courts to settle a dispute, controversy which could be settled peacefully outside of or without the court. An official, officer of the court, policeman, etc., must demonstrate that he or she is individually bonded in order to use a summary process. An official who impairs, debauches, voids, or abridges an obligation of contract or the effect of a commercial lien without proper cause becomes a lien debtor, and his or her property becomes forfeited as the pledge to secure the lien. Pound breach, breach of impoundment, and rescue is a felony. It is against the law for a judge to summarily remove, dismiss, dissolve, or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. Hazard bonding of corporate agent. All officials are required by federal, state, and municipal law to provide the name, address, and telephone number of their public hazard and malpractice bonding company, the policy number of the bond, and if required, a copy of the policy describing the bonding coverage of their specific job performance. They're required to provide this stuff.
Yeah.
Yeah.
Now those were, just maxims that should be lawful, for the lawful processes to happen. These maxims are important, and it's crazy. And they were talking about the public hazard. I've never heard of that before, but when I was looking into this stuff, it was so heavy learning this that you just read what they have to do. You know, they got to get copies and the numbers and stuff. But public hazard bonding of corporate agents is a legal requirement under the federal, state, and municipal law.
Yeah.
It mandates that public officials, including corporate agents, provide their names, address, telephone numbers to their bonding company.
Yeah. And if you ask them for it and they say, oh, I don't need to do that, they're blowing smoke up your ass. They're lying to you, and they're a criminal. They're a fucking criminal.
Woo!
Ask them for it. They have to give it to you. Bottom line.
Well, yeah. So along with their number and copy of their policy detailing their specific job performance, failure to provide this information can lead to criminal charges and civil liability. Now, we all know, we should all realize that, you know, if they don't do these things, criminally charge them, as it constitutes corporate limited liability insurance fraud. Now, here in Ohio, the DAS, it's the Department of Administrative Services in Ohio, administers these bonding programs. You know, it's probably different in every state, but I'm sure it's some type of administrative services in other states. But they're ensuring the protection of the state assets and their liabilities. Now, on Dun & Bradstreet's, if people don't know what that is, Dun & Bradstreet is an online kind of rating agency. You know, they rate your companies. You know, it's kind of official for becoming a company. It's an official rating service for both public and private corporations. Utilities and municipal bonds ratings would be under Dun & Bradstreet's purview for certain. I never ever stopped to think about to scrutinize the fact, yet alone allow my deliberation to research skills and wonder into research that would have disclosed that we recently found. Part of these discovering complex web interrelated interlocking corporations had to do with this electronic research over the internet. Years ago, if one wanted to search anything without any of the rating agency services like Moody's or Standards & Poor's or Dun & Bradstreet, other ones would have had either been a subscriber to that service, or in order to manually expedite their search results, or would have to pay a fee and cause a search to arise. But Dun & Bradstreet's ratings are effective every time a public hazard bond or surety performance bond or indemnity bond is complained against. An administrative complaint is usually all it takes to cause a tag or a book entry to be made on any particular bond. Any particular bond, once complained against 3 or more times, causes a change in the underwriting of the bond. The bond's changed to a risk. So what it's saying is, if the people making complaint to these bonding agencies, like if you go into these courts and they railroad you, you make a complaint to the bonding agency that the judge, the policeman, whoever hasn't done it lawfully or right, 3 of them complaints can make that bonding agency change the status of their bond to a risk. And once they're on risk, they're unbondable. So once they're unbondable, they're gone.
Right.
Judge,
and they don't even allow any
gone. What was that?
Yeah,
Adam?
they don't even allow you to. Yeah, they don't allow you to bring up any type of indemnity bonding. Like if you wanted to do that prior to maybe a hearing or something, post one on the docket so that way you're covered. And they don't pull the, oh, well, I'm going to have you, do a $5,000 surety bond, for instance. First of all, there's a lot of different steps that they're skipping by just jumping straight to that. But to cover yourself, if you try to put your own indemnity bond on there, they won't accept it. Why? I don't know. I mean, usually it's because they're corrupted and advised not to accept things like that. Or jurisdictionally, it's just not, they're non-judicial persons operating those places anyway. So,
yeah.
Any comments from either of you? No.
Well,
All right. So
you get a private indemnity bond number, and I use that for business, and I've had companies accept it.
Yeah.
So
probably different there because you're dealing with a a service that you're providing. Whereas when you're dealing with the tribunal, you are the value. So what, you're not, they want your value. So you're providing them with something, but they're not in return providing you with a remedy or a path to a remedy. That's where we always refer to them railroading you, because they skip steps. They don't follow the guidelines that govern them. And then they're constantly changing internal policy. So that way, for people that want to be pro se and play in their sandbox, they get shafted. So, I mean, it's really stacked against you. That's why we advise not to mess around there.
Hey, real quick, I have to, I seen something in the chat. It had to do with Ohio, so we got to stop. It says, Tim Plumley, Monday I tried to become a state nationalist on Ohio. Well, Tim, we're not nationalists. That's some kind of crazy group there. We're nationals, state nationals. In Ohio, we have a website, but you don't need no credit card. It doesn't take any money. You don't have to pay to become part of an assembly or change to an American. So maybe you might want to look into, the website is www.myohioassembly.com. Look into that, and that should be
sounds like
a good way to get there.
Sounds like he went to one of those other district assembly type websites. There's a lot of different ones out there, guys. Just make sure you get the right one. So
thank you, Allie.
Oh yeah, we're talking about. Yeah, thank you. For bonded bar attorneys, who in many cases also may be appointed, commissioned, or elected to public office as a judge, a clerk of court, etc., when and if their bond is complained against for good and reasonable cause, their bond may be pulled, and due to a loss of effective bond or suretyship, they cannot practice or discharge the duty of the office held or occupied. In short, the bondmaker issuer is the bonding party for the benefit or on behalf of the bondee, i.e., the purported public officer, employee, or official. This would extend as well to all other public employees and agents, agencies, etc. Every person being bonded has a Dun & Bradstreet bond rating. At least it is reasonable to assume such. Once 3 complaints are filed against any bond, assuming they are with merit and supported by fact and law of the breach of fiduciary duty, the bond is most always pulled or revoked. The servant at risk, by assuming the responsibilities of operating in any official capacity or by employment, can no longer be underwritten as a no-risk or low-risk contract. One incident of breach or operating ultra vires or without the law causes the immunity provisions of the written law to cease to be effective, because when one violates the law as a public servant, one's immunity blanket ceases to apply, thereby leaving the issuer or bondsman or bond issuer exposed to the liability arising from the servant's acts, which under any breach of law authority causes or gives rise to any injury, which is a civil or criminal commercial liability. Everything, whether civil or criminal or martial, is a matter of commerce and Admiralty law in the venue and jurisdiction by which disputes in of commercial nature are resolved in truth and fact. Now, when they say truth and fact, they allow a lot of hearsay without documentary evidence or legitimate proof. So don't let that catch you guys up. Just, they're lacking some foundation there.
Yeah. All writings of the United States of America and of the United States or any other government unit are forms of making offer to contract. There is no written matter of material fact or issue of fact that is law, which is not bonded. There is no office or function of civil service or public function that is not bonded. If the bond is not in existence, the bondee is exposed without coverage by any surety. Therefore, there is no grantor behind the agent, officer, official, or employee having exposure. By assumption of risk, of material breach or injury in fact by the bondee, person being bonded or insured. This leaves the person under the taint or cloud of operating in the public interest without the constitutionally and statutorily required bond, and therefore in tacit violation of the constitutions and statutes under the scheme of law. Law applies first and foremost to government, its employees, officers, and agents.
That's
If they're not bonded, blowing smoke up your ass.
yeah, that's interesting, because if they're not bonded, they're out in the open, and then it would be on them. I mean, it's their own, they have to make sure they're bonded.
Yeah, if not, they can be held personally and commercially liable for everything that they're doing.
Exactly.
Yeah.
Yeah. And I think we're going to get into, they say once in a while, I see videos where these judges will say, no, they don't have a bond. Well, just saying that on camera, they should be dragged out of the courtroom right then and there. Just saying that you don't have a bond.
Yeah.
Means your oath isn't worth shit. And what are you doing?
Practicing law from the bench, of course. Theatrics.
Crazy. Well, in today's rogue doctrine of necessity, de facto environment, research has proven and documented that no person performing as an officer of the court, being an alleged judge, being a bar attorney of the ABA, which is the American Bar Association, or the federal or state bars, has a bona fide constitutional oath. The bond that is supposed to be in existence sits atop that oath. The oath is merely incidental to the office. It has been ruled in some states by their corrupt courts, officers. The oath is what imparts lawful and legal authority to the man or woman coming into holding a public office. In becoming a public official, a public servant having no proper oath cannot have a proper bond to encompass or include those risks associated with the office. Discharge of fiduciary duty of the office and the various levels or elements of lawful authority underlying the office. Hence, one may take an oath to an office of the incorporated state or the all caps United States and not take a preceding oath to the unincorporated de jure or United States of America and operate unconstitutionally, which is all that has been going on for years, but which was not known or understood as being material breach to the people of the state, causing or giving rise to material injuries, in fact, as a consequence of operating ultra vires, which is outside the corporate charter or trust indenture, which created the office in the first place. That's interesting. So what they're doing is they are taking an oath, but it's to our subcontractors' constitution. They're not taking an oath to the American Constitution, the de jure 1787 original Constitution. They're taking an oath to our subcontractor service provider Constitution. Crazy.
Right. Well, in the all-cap state of Ohio, not one ALJ administrator, aka actor judge, has taken a necessary oath of office, which include the organic state de jure republic oath for Ohio and the subsequent and inferior or lesser oath for the state of Ohio. The latter public entity has federal charter and, federal character and federal employer identification number, federal tax identification number, and as a federal instrumentality of the all caps corporate United States and the all caps District of Columbia under definition of 28 USC 3002 subsection 15, 26 USC subsection 7701 at section A, 9, and 10. This document fact pertains to every judge in every state court, but also applies to most every other public official or law enforcement officer. So remember that stuff. It's
Well,
important
hey,
to know.
I got a question. Do you think these judges or these and commercial sheriffs, judges, the prosecutors, do you think they know they're taking the wrong oath to the wrong Constitution?
I think they're just worried about getting a salary right when they get done with college to start paying back whatever they owe student loan wise. And I think that maybe it takes a little while to figure out what's going on. For some, it could take a couple years. Others, it could take a couple decades. Just depends what type of law they're practicing.
We have, a commercial sheriff just doesn't get elected out of the blue. He usually comes up through the ranks, probably a deputy first. So they have to know what they're doing, and they're still doing it wrong. You know, I've sat in the commercial sheriff here in Richland County in his their big room they have there to watch a deputy get sworn in. And, they put raised their hand and said their little spiel. And I know for a fact that deputy had no idea what's in the Constitution of the United States of America, but he swore an oath to it. How is this shit possibly going on in this country?
Couldn't tell you.
Is this intentional, or are people just that ignorant?
Well, actually, I can tell you, but just to summarize, I mean, if they would get familiar with like Article 4, Section 2, Article 4, Section 4, kind of figure out there, it'll tell them, what type of violations they're doing, what they're not supposed to be doing. If they would actually read, they would learn. But a lot of them take an oath to the state constitution that they serve in, for the most part. But then when that FARA registration comes shortly thereafter, that kind of nullifies it. So they're not constitutional sheriffs. They're commercial. They're under blanket policies. And they have collaborative agreements with the municipality to commit all of those fancy emolument violations and to enforce these administrative warrants that are not stamped with raised judicial seals from non-judicial persons. That's a crime in itself. They're not enforceable. So, yeah, I challenge anybody, to go over these orders that these people are, supposedly e-signing or signing without their proper titles or without the stamp or seal from the courts. No law was created, therefore enforceable.
You know what I think is really crazy? The emoluments violations. Right. These guys, we're paying them to break the law against us. We're paying them to. It's insane.
Yeah, exactly. That's what pisses me off the most. That's why I'm here. They need to know. People need to know.
I cannot address what other state public pretenders and district attorneys or prosecutors do when bringing a criminal complaint against any natural person, which includes corporations. Yes, there are both class of persons under statute law definition, but in the state of Ohio, when it is the bringer of the action, the people of the state are never brought in as party to the action. Only the corporation name is found on the criminal complaint or in information form. Only the corporate state is present in the courtroom trying a case before a corporate judge. There exists a complete breach and break from the Constitution of Ohio because the people of the Republic of Ohio and their law are not present in the action nor party to it. They are not in the courtroom, nor are they acting through any officer of the people.
Exactly. That is basically what everybody refers to as the straw man. The corporation, they're in there. The man or woman is not in there.
Right.
So for victimless crimes, anytime the all caps state of whatever state is claiming to be the plaintiff, usually the Supreme Court, the U.S. Supreme Court, is the one that holds original jurisdiction, because they can't be an attorney and a witness at the same time, and this is the line that they cross daily. I witnessed it happen probably 7 or 8 times, from about 8 o'clock in the morning till about 11:40. I just was sitting there shaking my head in disbelief. Like, what are they? Why are they moving forward? They don't have jurisdiction. What are they doing? It's because people don't know how to stand in their square and assert their rights, their unalienable rights. They don't know the Constitution. They don't know that these people are committing all kinds of due process violations and moving forward without jurisdiction or authority to do so. And if you don't know any better, you're getting railroaded. That's just the name of the game. And these prosecutors, assistant prosecutors, are the ones provoking this. They're guilty. They're acting in a criminal capacity to deprive you of your rights, and basically it's for profit. So,
well, Adam, that's what we're trying to do here. We're trying to make the people out there, this audience, aware. Like I said before, you can definitely go into these C jurisdiction courts. They're foreign to us, but you can go in there and try to fight your battle with the USC, UCC stuff. But you have to know what you're doing. You have to know that stuff inside and out, and people don't. They go in there and, I give them credit for trying. They're in there babbling all kinds of stuff, and they don't know which way they're going. And the judge just keeps railroading them. But what we're doing
buy
here
a law book, whichever type of law.
What we're doing in the
state,
assemblies,
study it.
What we're doing in the assemblies is trying to restore our courts. We're not trying. We have our court restored. It's happening. And hopefully it happens in Idaho with Chad and their assembly. But there's, Florida's doing good. Louisiana's doing good. South Carolina's doing good.
Right. Yeah.
I know there's other states, and we're bringing back our court system, so that you don't have to know all this bullshit and stop getting railroaded all the time.
Go into those courts, though, and something that everybody needs to know: if you willingly go into those courts, you're subjecting yourself willingly to that jurisdiction. They are completely foreign with respect to Americans. We should never go in there for any reason. And if we are in those courts, it should be because we've been arrested. We've actually caused harm to somebody else,
Right.
Outside that, you should never be going in those courts, period.
Exactly. And that's what we're trying to tell people, and that's why we're kind of going over some of this stuff. Like I said, if you want a little bit of remedy before your courts open up, that's cool. I would do the same thing. But you need to join your assemblies and start getting your courts up and running. That's what it's all about, people.
It takes roughly 73 people for a county to get your jural assembly up and fill some of the other vacated seats to get your county going. So it's not that many people.
All right. Well, absent performance according to bonded statutes regarding bond oaths leaves a clear and certain risk liability issue for the bond maker issuer. Some bonding agents have bonded the statutes on other writings of the law of the state. Some bond issuers has bonded state employees, officers, and public officials. And some bond issuers has therefore underwritten risk on the basis of having the knowledge that there exists no constitutional oath beneath the corporate oath. One cannot but presume that the bond issuer makes a full disclosure. After all, they have been registered within each state department of corporations doing business in all states and the District of Columbia, and are presumed to know the law, including the law of the land, which under their Uniform Commercial Code, UCC, and all the secondary civil or criminal codes would find itself to be in harmony with the legislative, judicial statutes and implementing regulations at the UCC 1-308, 1-207, and 1-103, wherein all rights are reserved, and the UCC states that it is harmonious with all jurisdictions, which would include the jurisdiction of the law of the land, common law, and the various common law constitutions of underlying several de jure republic states of the American Union, aka the United States of America.
I don't think I've seen 1-207 around since the late 90s, to be honest. I haven't seen it. I haven't seen attorneys use it. I think attorney actually said something to that effect, that it hasn't been around for a while. So, but again, we don't really use a lot of that type of stuff. You could just put void where prohibited by law, and it's just as effective. All rights reserved, whatever.
Yeah.
But anyhow, why would any bond underwriter knowingly underwrite these corporate states, United States, and all their subcorporations, agencies, instrumentalities, and their law authority found in their various writings, private law, etc., to operate a public or municipal construct as if it were lawful government? It's not. That's bullshit. But knowing that is a reality or not, the underwriters of bonds, therefore, could not allege any defense against a massive intake of related claims by private bonds. Therefore, inhabitants of any of the states or United States who have been compelled under duress, extreme duress, threat, duress, coercion, or risk of extreme duress and prejudice, of seizure, confiscation, impound, occupation, detainment, or injury or termination by any means of potentially lethal force. So, that happens 99% of the time from what I've seen. They'll send you something. They'll send your administrator or the legal fiction something in the mail, and it'll say something like, failure to appear, you may be fined, license suspended, potential jail time, or a combination of the three, if you don't basically show up and perform in their legal process. Well, you have the right ultimately to decide who you contract with and who you don't. That's an offer to contract. So, there's a way to not accept that contract, but chances are they're going to do something administrative to put you under threat, duress, and coercion, or under threat of arrest, because you're not playing their game with them, right? This is where these administrative warrants come into play. So, anyhow, Chad, you're up.
Yeah. Everyone who's ever been inside a state of North Carolina administrative or judicial law proceeding, or been before any clerk or judge of the same, or been prosecuted by any county district attorney within the said state, all cap state, has been within Brutum Fulman. Now, Black's Law Dictionary, 4th edition, Brutum Fulman, empty noise, an empty threat. A judgment void is a judgment void upon its face, which is in legal effect no judgment at all, and by which no rights are divested, and from which none can be obtained, and neither binds nor bars anyone. Dollar versus Pratt Hewitt Oil Corporation. And then it's got the case numbers.
Yep. Void ab initio.
Yeah.
Empty noise, empty threats.
It's what it is.
Yep.
The office of sheriff is the most important link between the people and the de jure state and the courts and the offices of the state. However, it's been discovered that many sheriffs do not, as the chief law enforcement officer of any local county or county, has a bona fide prior or precedent constitutional oath to their respective republic state. So what we're talking about here is the commercial sheriffs, not us. We are lawful peacekeepers, soil jurisdiction, You know, we are the Americans here, not the commercial corporate side.
We're the guardians over them.
Yeah. They may have been taking a bona fide constitutional oath, and then they disclaim or disavowed it immediately, henceforth by taking a corporate or constitutional oath. And a man cannot serve two masters. So like Adam was saying before, you know, that they will take this oath to the corporate constitution. And, you know, by doing that, they're supposed to fill out their FARA registrations, Foreign Accreditation Registration Association or something like that. What is FARA?
Foreign Agent Registration Act. Yeah.
Yeah, Foreign Agent Registration. They have to fill that out, notifying the public that they are a foreign agent because they're not American, people.
And the DOJ is supposed to keep record of that.
Yeah. Well, they're not doing it. And they got everybody in these counties and their communities hoodwinked, you know? They're foreign. You like that word?
Not American.
Right.
And like it says, you
up all the
can't
time in
serve two
history.
masters. You cannot serve the commercial administrative government and the American government at the same time.
Right.
Can't be done.
Right. I mean, even if you try to rationalize that, you know, where you're on the clock versus off the clock and dual citizenship and all that type of stuff, it can't be done. You know, at least not to benefit the people. So this same axiomatic principle applies to officers of the United States as well. This is the uppercase and lowercase United States. How can the newly sworn Attorney General of the uppercase, all caps United States, Office of Attorney General, federal corporation take a constitutional oath to the uppercase lowercase United States or the all caps United States and be held to such an oath as liable for his or her breach of fiduciary duty to the people of the uppercase lowercase United States of America or to the franchise corporate trust estate, citizens of the all caps United States, when the office charter contract at Article 30, shortly after taking said oath, Article 30 is quite explicit in meaning and intent. If one understands the international purposes of the Interpol and all other international agencies was and is to establish a financial dictatorship within the United States of America, for the benefit of undisclosed third parties, under jurisdiction and authority, the IMF, UN, then all of the lower level breach of duty by lack of proper bond and oath issues would begin to make a clear sense, right?
Yeah.
No. In short, all alleged public servants are serving public policy and public administration of the laws and enforcing those laws to protect the corporation to the disinterest and detriment of the people whom have been captured, searched, seized, boarded as with a vessel, and which people have been placed into warehouse storage as human capital and property of the de facto king or sovereign, which who has conquered and occupied the office of the people and subverted and subordinated it into an office of inquisition, or you know who.
Yeah.
Yep.
Yeah. Hey, real quick.
Sounds
I
like
see another thing in the chat from Brad Porter. Your thoughts on we are an occupied nation. Soon we will be occupied no longer. Donald J. Trump said that 4 times. Brad, you have to know this. Donald J. Trump is not an American. He is the president of one of our subcontractors, a foreign corporation. He's the CEO of a foreign corporation. He's not an American president. So that's we get that a lot. A lot of people don't know that, but fact.
People have been fooled by what's going on. He is not who you guys think he is. He is not a declared American. You find me a document declaring himself Donald J. Trump, an American, on the public record. Find it. He wasn't even born in America.
Yeah, well, you know what? That comes in with that title, Commander in Chief, too. You know, Commander in Chief is a military
Naval office.
Yeah, naval officer. So,
Yeah.
you know, I think that started when
We all
when Lincoln,
know
with
what
Abraham
Abraham
Lincoln.
Lincoln did.
Yeah.
Here's another thing real quick I'm going to
Right.
throw in there. Donald Trump, along with Peter Thiel and Elon Musk and a handful of other billionaires, filed a LLC out of London. Was it in 2019? You guys know what year that was? It wasn't
Yeah.
very long ago.
Yeah.
Yeah, 2019, they filed a new LLC for USA Inc. or United States LLC in
Yeah.
London. You can look this up. He's operating as a corporate officer, you guys. He is not a declared American. So anybody out there that you need to do your research, you're being lied to on all.
Another thing.
And most alternative outlet media, I mean your alternative podcasters, they're not going to tell you this shit. You have to look it up for yourself.
Yeah.
Right. These federal corporations and subcontractors don't have the authority to declare war. Our American government does. It's in session. But our contractors don't have that authority. Our CEO of one of those corporations does not have that authority. Commander-in-chief or not, foreign agent or not. That goes through the American government Congress, not through the de facto. So that's something that's been misconstrued for a long time now, and it's starting to come to a head. You know, this information is getting out, and I'm happy to see a lot of other like-minded people studying constitutions and the differences, and I see it all over on social media.
Yeah, I get into it. You know, I have gotten into it a lot with people because when I say, you know, what's true, they'll be like, you just don't like Trump. No, I voted for Trump in 2016. Before I changed my political status, I was a Trumper. I thought he was the guy, you know, because he makes a lot of sense. So I'm not against Trump. But once you learn what's going on in this country, you can't, you know, it's fact. It's fact that he is the president of a foreign corporation. You know?
Yeah, I've seen somebody in the comments say thoughts on EO executive.
Yeah, that was Brad. That was Brad again. And
yep.
Them executive orders he's making means nothing to Americans.
Yeah,
means nothing to
Americans. Executive orders. Take all those executive orders and toss them out the window. They mean nothing to us. Has nothing to do with.
We've already debunked, you know, all of the terminology and language they're using against Americans, and we also see how they're screwing over U.S. citizens too, calling them enemy combatants of the state and domestic terrorists. It says it right on the FBI website, so go read up on that stuff.
Yeah.
But yeah, Americans aren't in that bucket, and they're not going to misidentify or mischaracterize us. They don't have the authority to, and they never did have the delegated authority to.
Yeah.
But if they would like to get the history on what sovereign and citizen both mean separately, they could go to the PKTF hub, and they could read up on all those articles pertaining to that. We've already debunked the myths of sovereign citizenship.
I was going to say, well, there, Josh McAfee in the chat. Thank you. This is all basic knowledge these days. Yeah, it's pretty. I think people are starting to really understand what's going on.
Like a prairie fire, man. People are waking up. I mean, a lot of people that I knew that were big time Trump fans just in the last, you know, year, 8 months, they're starting to wake up. You know, they're seeing the fraud on both sides.
Yeah.
So,
well, I don't have, you know, I personally don't have nothing against Trump. He's one of our employees. You know what I mean? We need to rein him in a little bit, but he's an employee of ours. You know, he's a subcontractor.
Yeah.
All right. Lacking mandatory oath creates liability against the bond of the state, and every officer, agent, employee who has come to be employed thereby, breach of breach of any underlying writing of the state or state has an offer to contract in Admiralty venue. This is certain injury in fact giving rise to a material injustice, the resultant liability. There is no longer any question about risk analysis or damage assessment. The only real issue is how much is the injury worth, what penalties should be compelled above the mere pecuniary or monetary relief to the other
Pecuniary.
side.
Pecuniary.
To be sought. Treble damages or punitive damages, civil or both, criminal. So basically what we're saying is, because of all this crap that's going on with the wrong oaths, the wrong bonding, not having bonding, this is causing injury to Americans and U.S. citizens. So who's liable for this? Is it criminal? Is it civil? We're going to find out.
Well, it's the man or woman who sometimes acts as a governor, or sometimes acts as a Leo, or sometimes acts as a ALJ, whatever, position they're in. At the end of the day, in our jurisdiction, they can be held liable because trespass upon rights is a grievous act, right? Usually with malicious intent.
We went over this before, that whole immunity and all that stuff. They do not have immunity. No man or woman. If you commit a crime, you do not have immunity.
Right. In fact, it actually says in their policy that if they violate somebody's rights or commit a heinous act, while in the commission of whatever their duty is, that immunity shield is lifted, right? There is no such thing as total immunity. I don't care what anybody says. That's a crock of shit. Qualified immunity is a made-up myth.
Real quick, too, I want to add something to that. In our jurisdiction, in the land and soil jurisdiction, if someone trespasses against you, causing you harm, and commits a crime, that is a crime. A trespass is more serious than a crime. If someone trespasses against you, you have no immunity against that, and there is no statute of limitations on the land and soil jurisdiction. So bear that in mind and act appropriately all the time, because eventually all 50 state general assemblies are going to be up. And if you've trespassed against somebody, there's nothing stopping the victim from whoever you did that to come back and seek justice.
Oh, yeah.
Yeah, and we don't do attorneys in our jurisdiction either. So you're not going to have some type of representation. It's going to be you standing on your own and, probably wishing that you didn't make some decisions that you did. Right. That's how it's going to go down. You on your own because you acted alone, or maybe perhaps in a group. They'll get dealt with the same way. So it's time we start bringing back some of these public events in the squares. Hasn't happened since 1925, and we're really close. That's going to start happening again. Not because we have a bloodlust or, that's what we want, but some of these people do not want to learn. Some of these people are greedy little pigs, and the only way to teach them and their buddies is for some of them to, keep pushing. They'll find themselves on the other side of the law. Not all that legal fiction stuff.
Right.
So anyhow, oaths and bonds, have not yet been ascertained for all relevant federal or state officers, agents, and employees. They should be compelled by FOIA request or subpoena, duces to come immediately, so that elements of contract and breach of duty by these public servants under mandate of relevant constitutions, statutes, regulations, etc., including the UCC and Admiralty venue, can be comprehensively determined, then resultant cause of action, instructed accordingly. So, that's a mouthful in the way it's worded, but I guess go back and watch a second time and listen to it slow.
Yeah, It is furthermore axiomatic that where liability and equity arises due to injury by another party or by any party, and that party does not also provide a remedy for said liability, the injured party has the right and standing to create his own remedy. Persons without proper oaths do not and cannot have proper bonds or satisfy the necessary requirements to hold a bona fide office by commission or election or appointment. In short, an officer or office holder cannot but occupy the office under false and misleading pretense, misrepresentation, and fraud, which strips the individual of law authority and immunity. Yep, lawful authority and immunity under well-seasoned law of the land and sea. Brutum Fulman, remember that was empty? Anyway, bonds that are attached to such juristic persons are subject to claim and lien after adequate assurance of due performance has been found lacking pursuant to UCC 2-619. A proper oath and bond are but two of the three primary poles of office. Oath, bond, and commission. One cannot act upon being duly appointed or duly elected or duly commissioned simply by incorporation or corporate administrative processes.
Interesting. Well, you know what? I've been reading a couple of the comments. Josh Brown has got, I guess, you know, if you're speaking the truth, that's a sad situation. So sorry, Josh, but you know, if I was you, I would change my status, join our assembly. You know, we're right here in Ohio, and you know, you can help us build, and we, you know, the faster we grow, the faster we can get help to you. And you know, once we do get basically the recognition that's needed to go out and apprehend some of these guys that are partaking in them crimes, it's going to be a lot more harsh than what you see nowadays. You know, this child abuse and these pedophiles, there's not going to be much mercy on them. I can tell you that.
Something about that too. Our laws are very, very simple. Basically one law, do no harm. But our courts, if you come into our courts, our punishments in our courts are heinous. You do not want to go into our courts. These child molesters will see no mercy. You trespass against somebody. A trespass is spiritual. You fuck with somebody and you're going to pay. And in our courts, you will see hangings. You'll see people put to death a lot more often than you do in the de facto courts. I guarantee you that.
Yeah, it goes for contentious co-parents too. I mean, they think that they're going to manipulate a child's mind to, you know, cause all kinds of issues in the other home on that other home's time. You know, those things can be, you know, swiftly handled too. And there's nothing that the statutory side is going to do to save anybody. So
yeah, you know, it's been that way. Probably, you know, most of the time it's been that way. It's just here recently where all of these penalties have gotten less and less, and I think it's due to money, because once they get these people, these so-called criminals in the system, taken to court, in and out of jails, in and out of prison, that's money. And they know that. Right. They rely on that. They know, you know, a lot of you people know the system. They let you out of prison, but you're on paper for 5 more years. You know, you're already, you know, most of these guys half of them are junkies. You know they're going to recommit. you know they're going to go right back in. The recidivism is pretty bad in Ohio. I imagine it's the same in every state. It's just money.
It's designed to keep you stuck in the system.
Yeah.
You know, it starts from when they're in public indoctrination camps they call schools. They get profiled there, and it branches out from there the rest of their life. So, you know, these people are the first people in your youth that start putting you on paper in a negative way, and that follows you the rest of your life. So that stuff's going to come to a stop too, or just profiling in general. It's unnecessary, and they don't have the authority to do that. So, go ahead. You look like you want to say something.
Me? No, I was going to say.
Oh, it looked like Chad was going to say something.
Go ahead, Chad.
Yeah, well, yeah, I was. I just wanted to let everybody that's watching know you can join your state assembly, and if you have had some pretty bad trespasses against you, you can fill out a criminal incident report with your soil jurisdiction sheriff and have it on file. Now, that case may not go before the Ohio Jural Assembly or the Idaho Jural Assembly immediately. I know as far as Idaho goes, our Jural Assembly is up, but we're not taking cases unless it's involves loss of life. I mean, it has to be a really big deal right now. We've got a lot of work we're trying to do to get all pillars of our government up. But you can fill out a criminal incident report and have it filed with the recording secretary. It'll be, I think they upload them to the LRO, the Land Recording Office too, right? So these are all cases that we'll see our courts. That's all the more reason for you to get your status corrected and join your state assembly. Help put your jural assemblies together, because you can fill out these criminal incident reports. These people that are trespassing against you are not going to go unchecked. I promise you. But this requires action on every one of your parts to get involved. We have a responsibility to assemble. I've said that times on this. We have a responsibility to assemble. And once you wake up and you realize what the hell we're actually talking about by correcting your status and joining your state assembly, it'll happen fast. If everybody on here corrected their status tomorrow and shared with somebody else, this whole shit show could be over in a matter of months.
I agree. Thank you for saying that. It's about time. You people out there watching, grab a damn friend, make one person. That should be your homework for the week. Grab one person and say, hey, let me show you the way.
Right.
We need
and if
you.
your state assembly isn't for you and they don't seem like they're progressing forward, then go down to your county and get your county assemblies going. That's where most of the change is going to take place anyway. So, like I said, it takes roughly.
Sorry, Adam. I was going to say, remember, when we talk about your state assembly, we're talking about the unincorporated state assembly. You got to remember that, because there are all kinds of incorporated assemblies.
Right.
We're unincorporated, which means we have no charter above us. We have no parent company telling us what to do like our subcontractors do. You know, they're chartered by Crown of England.
Go to standup.land. Standup.land. American State Assemblies.
Well, I hope everybody got something out of tonight. We just wanted to give you a little bit of information. Chad, you got any social media that you like to shout out?
I'm just on Facebook, Chad and Jamie Morgan.
There you go.
Send me a friend request. I mean, a lot of people here in the comments. I've talked to several of them on the phone. I'll call you. I'm not man. I'll get on the phone and I'll call you. If you have questions, hit me up. Send me a friend request or message on Messenger. I'm semi-retired. I spend all my time working on building my assembly and trying to direct you people to your state assembly. Okay, I'm here to help. I want this over with. I want the shit show to end. It's about everybody else, but it takes committed action on everyone's part here. Okay.
Well, hey, the Peacekeeping Task Force Director, Joe Hayes, has wanted me to let everybody know that the PKTF podcast is on Podbean now. If you go download, go to the Play Store and download Podbean, you can listen to all his podcasts. Really informative. I recommend it for all military people, all commercial sheriffs, Leos, you know. But anyways, we wanted to thank everybody for stopping by. Adam, appreciate your help. Chad,
No
appreciate
problem.
you again. You guys just remember, hey,
Quick shout out to,
yeah, go ahead.
just wanted to give a quick shout out to Rodeo on TikTok, Mac Russell, Lee Daniel, as sweet as can be. Good people. They're out there educating people on, you know, their unalienable rights. So keep doing what you're doing. We see you.
Yeah, thanks, guys. But just remember, it's not just about you. It's about your children, your community, your country. Their system only works if you stay asleep. So wake up, stand up, and frickin' speak up, people. Come on. Thanks a lot, guys.
Amen.
Love y'all. Have a good night.
Have
All
a
right,
good
we'll
one.
see you all later.